Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Texas and Virginia. It is May the 3rd of 2023, and we are here with your legal news roundup. All the legal news going on in your world so that you can be better legally informed. We begin with the ongoing lawsuits between Disney World and the state of Florida regarding control of what was the Reedy Creek Development District, and also, of course, its impact on the park and the private entity that is Disney World. Disney World, of course, has previously sued DeSantis, and now DeSantis is suing Disney World in this continuing lawsuit over control of the district, the governmental entity that is the district, and also its impact on the private entity that is the park. So we have two forces that are involved in this, the governmental entity and the private entity, and their interrelation there too. So we're trying to continue to do this, and now DeSantis's board has filed suit against Disney in response to Disney's suit against DeSantis. So fun and exciting times there for sure. The district board that is now in control of this area has filed suit in state court escalating the lawsuit. The 188-page lawsuit asks the courts to render void and unenforceable the grant that Reedy Creek granted to Disney World just before Reedy Creek ceased to exist. So one of the last things that Reedy Creek did was create this grant, this contractual grant of power to Disney World, to basically try to transfer all the governmental functions effectively to Disney World so that Disney World would remain in de facto control of the district, even as the government tried to take over. And so now they filed a lawsuit saying, okay, this grant, this contract, this paper you put together is not worth the paper it's put it on. So the lawsuit specifically targets the arrangement set up with the board in which the company tried to invoke property law and then said, okay, this will be in place at least until the last heir of King Charles III dies, trying to get around rule of perpetuities problems. So it's like, okay, forever or until the last heir of King Charles III dies, to try to make it against rules against perpetuities. But of course, that isn't the only issue in play here. There are more underlying issues than that. The agreement, if it were valid, would give Disney control over its land effectively forever, or close to it. So that's what they tried to do, and of course, well, maybe they shouldn't be allowed to do that. The countersuit comes after Disney sued the governor and the board, alleging DeSantis and his office have engaged in a targeted campaign of governmental retaliation against Disney that was orchestrated as punishment for Disney's speech. And we've tried to talk about this a little bit before because things get very legally complicated in this domain. Because we have two entities in play. We have Reedy Creek Developmental District and Disney World. These are distinct things. There is no dispute that they're distinct things. Their interaction with one another is, of course, where things get interesting. It would be like saying that Orlando is distinct from Disney World, or the state of Florida is distinct from Disney World, in that same sort of way. But of course, Orlando or Disney World or Reedy Creek or whomever it might be that's trying to impose on Disney World, to the extent they're trying to impose on a private entity, then you have potential issues. So government gonna government, but when they do things against private entities, particularly if they're done in a way that is a violation of constitutional protections like First Amendment issues, you might have issues. But the thing gets complicated, of course, on a whole bunch of things. You have to go back to the original grant of power to the board, to the district. You have to go back to the original grant. You have to go back to the mechanisms by which Reedy Creek attempted to give notice about this, and whether or not they gave effective notice, and whether or not there's a whole bunch of legal issues in play, as I'm sure you can appreciate, in trying to undo this relationship to some degree. The chairman of what is now called the Central Florida Tourism Oversight District, because they gave Reedy Creek a new name. So it's no longer called Reedy Creek. Now it's called the Central Florida Tourism Oversight District, which I'm not really sure is a great name for it, but whatever. The chairman of the board says they have no choice to respond. We will seek justice in state court. We will seek justice in our state backyard, and all 5 board members support the motion, which makes total sense. I mean, they're appointed by the government. They're appointed by the governor to do the will of Florida. They are Florida legally because only Florida has sovereignty. And so, yeah, they want to respond to this. And some of this, at least, is a matter of state contract law. So a lot of this is state law specific. In fact, most of this is state law specific. Most of this gets into issues about how the district is created, how districts are dissolved, what kind of notices they have to give, what kind of control they have from the government, from the governor's level, right? So almost all this is state law specific. The contract itself, whether the contract is valid from first principles, is a matter of state law. Contracts are state law. So almost all this is state law specific, with a little bit of First Amendment retaliation thrown in potentially, and maybe some equal protection if we're putting our thinking caps on. But yeah, this is principally state law. So state courts are principally where this would go. The choice by the board to file the lawsuit in Central Florida stands in contrast to Disney's decision to file in the U.S. court. So Disney thinks the First Amendment issues are principal and therefore wants to file in federal court. Disney, the board, for its part, wants to file in state court. So that's fun. The case had previously been appointed to an appointee of Barack Obama, so potentially some rough roads for Disney in the U.S. District Court, at least for the immediate future. In an interview with the British newspaper, DeSantis accused Disney of foreign shopping for a judge who rules against them, which, to be sure, yeah, I mean, you're going to try to find the judge who is most likely to rule for you. Everyone does it. So, yeah. DeSantis, of course, is likely to launch a presidential campaign at some point in the near future. So this might relate to that as well. The board overseeing Disney's districts has met 4 times and hired attorneys and financial advisors as they consider changes to the self-governing privileges of Disney. They've also started a search for an urban planner and economic consultant because, among other things, they would be responsible for the roads and how those are built. And there is quite a lot of traffic around Disney World. So there's a lot of interesting issues there as you try to plan out the space and the interaction with the space. On Monday, Garcia expressed frustration about Disney's escalation. In essence, Disney is asking the federal court to wrestle back hands of time to 1967, when this board was initially created, instead of changing it with the 21st century practices. Disney is also having some financial problems. They've been having layoffs recently, which could be due to a whole bunch of reasons, including potentially their movies and people not particularly liking them as much as they used to. But Disney also has announced plans to invest heavily financially in Disney World to the tunes of billions of dollars. So mixed messages there from Disney corporate. Under a decades-long agreement with the state, Disney doesn't have to run its plan by zoning commissions or building inspection departments. Well, that's kind of true. More to the point, they had to run it by Reedy Creek, and they were Reedy Creek. So they had to get zoning commission and building inspection from themselves. So, that kind of made it easy. DeSantis' new board said nothing's off the table as it took to major overhaul the areas. In the mix, possibly higher taxes, regulations, something dealing with the workforce housing, which has long been a point of some interest as Disney, how they house their own staff or lack thereof has been an interesting issue over the years, and exploring the sale of utilities that the district owns because they generate their own power, because they use a lot of power. So they generate their own power. And so maybe we could sell some of that power to other parts of Florida as well. Asked about the lawsuit during an unrelated press conference, the governor said it was wrong for one corporation to basically corrupt the local government, run it their own fiefdom, which That's not a completely inaccurate description of Reedy Creek. Be exempt from laws and have all kinds of benefits. Disney had a lot of power over this district. It's not the only special district in Florida, but is arguably the most powerful special district when it comes to private control over things. So Disney World, I think, had more control with respect to its local district than pretty much anyone else. So it's not exclusively a Disney thing, but Disney definitely took it to its limits and definitely was using it for its maximum advantage. Okay, great. That's enough of that. Thus, that brings us to the end of the discussion for the moment about the ongoing lawsuit as it relates to Disney versus Florida, as it relates to the Reedy Creek Development District or the Florida Oversight Tourism District or whatever we're calling it today, which is definitely a governmental entity, and its interactions with Disney, which is definitely a private entity. For 50 years, the governmental entity and the private entity have been somewhat indistinguishable, although legally distinct. And so now we're trying to sort of undo that, and that's raising all kinds of fun and exciting issues. So I think on balance, as I've said before, I think on balance, Florida has the better end of most of these arguments because they have control over their own districts. And to the extent that Reedy Creek was trying to give power to Disney, it looks like self-dealing and raises some serious interests under Florida state law. The thing that comes immediate to mind is just unconscionability, as it's void for public policy. The contract is void ab initio because what's it fundamentally attempting to do is devolve a governmental entity's power into a private entity in a permanent way. And that probably can't be possible because that wouldn't make any sense. If you give governmental power to a private entity in a way that you can't crawl back, that sort of fundamentally violates the nature of what governments are, because now a private entity is the government. And that's really, really weird. So I think on balance, Disney has the better end of most of these arguments. Apologize. Let me redo the line. I think on balance, Florida has the better end of most of these arguments, but it'll be interesting to see how these cases resolve as they go through the various courts, both federal and state, with potential conflicting decisions, I'm sure, as we escalate this for what will be a year-on-year fight, I have no doubt. And that, for the moment, brings us to the end of discussion of that story. All right, good morning. Thank you, everyone, for being here. Thank you, Ellen Parker, as always, for your continuing support of the channel. We really do appreciate it. Thank you very much. As Simon notes, Legal Mindset has done some good stuff on Disney. Legal Mindset, excuse me. Legal Mindset has more specific knowledge than I do because he's actually done work in this domain with the creation of districts in Florida, which I have not done. Obviously, I'm not a Florida lawyer, and even if I was, I'm not this kind of Florida lawyer. This is not my wheelhouse. So I'm trying to use general knowledge to apply the situation, and Andrew has more specific knowledge because he's been involved in this situation in the past, not Disney itself, but comparable situations, or at least situations that would give him a wider and more specific knowledge base. So Andrew from Legal Mindset, excuse me, Andrew from Legal Mindset is definitely someone to look to this issue. And I am coming from a place of comparative ignorance on this issue, and I'm not afraid to admit that because, we all have our specializations. Andrew has, to the best of my understanding, basically said this is a slam dunk for Florida. I'm a little bit more cautious on that than he is, but I haven't watched every word of what he said, and so I may be somewhat misunderstanding his analysis. Maybe he's provided a more nuanced analysis than I understand, and also, of course, he has more knowledge anyway. So to the extent we disagree, it might be because he has more knowledge in this domain. So I think that you should go watch what he has to say about it. If you're really interested in the Reedy Creek Disney stuff, then go watch what he has to say about it and see what you think. He's obviously well informed. So, check it out. See what you think. What's my specialization? My specialization has been patent law, intellectual property law, but patent law specifically. And I have developed an expertise in constitutional law. So those would be the areas of my expertise, I would say, is patent law and constitutional law. So that would be my and also more federal law just generally. I am much more knowledgeable about federal law generally than any state law, including Virginia and Texas, where I'm licensed. I don't really know any Texas law. I'm a lawyer in Texas, but what is the Texas law? I don't know. I gotta look it up, right? So yeah. But yeah, my knowledge base is much more federal law. So federal law definitely, generally, and then patent law and constitutional law more specifically is my knowledge base. And then if you get into state-specific law, I go, I don't know. If you ask me about Texas state-specific law, I'll be like, well, I can tell you that in Texas, that there has to be a recording of a confession to use the confession in court, which isn't necessarily true in every state. So if like you're in a police interrogation and you confess, there has to be a recording of it. So if for some reason, like the police forgot to like hit the record button or something, they can't use your confession against you in court. So there's that. Also, what was it? Another one that I know. The Fourth Amendment applies to private entities insofar as evidentiary rules are concerned. So if a private person goes into another private person's house illegally and like discovers evidence, it can't be used against that other person. So the Fourth Amendment applies to private entities, at least as far as the evidentiary rules are concerned. I know that. Is that helpful? Generous also says I'm good at the YouTubey thing. I'd like to think I'm good at the YouTubey thing as well. Yes, thank you. Always assume everyone carries, says this Texan. Fair. Thank you, Generous, for saying I look handsome. I will always take compliments about my appearance. You bring warmness to my heart. You are awesome. Thank you. Good morning, everyone. Thank you for being here. Sorry again that I was absent yesterday, but sometimes Sleep and I really don't get along. It doesn't happen very often, but sometimes Sleep and I don't get along. I'll wake up in the middle of the night and can't get back to sleep or something like that. So, every once in a while it does happen. And yesterday was one of those days. I tried to wake up and I tried to pull myself out of bed. I was like, Have I covered any Ed Sheeran versus Marvin Gaye? Yes, as a matter of fact, I posted a edited video about it, I think yesterday. So yes, we've covered that lawsuit as well. And thank you for the $2 super chat as well. Appreciate it. Thank you. What's my favorite lawyer movie? Probably 12 Angry Men. Although I'm not sure, strictly speaking, that's a lawyer movie. Well, because it doesn't involve lawyer. In fact, lawyers never speak in the movie ever. I'm not even sure there are lawyers in the movie. It's about a jury deliberation. But 12 Angry Men might be my favorite. And 12 Angry Men might be my favorite. It's one of my favorite movies of all time. It's not a medication issue, Jerry. It's just something that's been true for a long time. Medication, yeah, it's not a medication problem. Sleep and I have a troubled relationship. 12 Angry Men, I think you can find on YouTube for free, I believe. So, it's a great movie. Oh, and I did get some stuff recently in my PO box that I haven't opened. Yeah. All right. My Cousin Vinny is a fine movie. Do I like John Grisham novels? I've never read one. No. So yeah. There are two 12 Angry Men. The one I'm thinking about is Fonda, 1957. I think it is black and white. So that's the one I'm thinking of. 12 Angry Men, 1950. I think it's 1957. Good movie. Black and white. Great movie. All right. Let's do a new one. Yeah. Fonda at his best. It's definitely up there. Yeah. I'm reasonably sure, Jerry. I've had these problems with and without various medications, so I don't really think medication is the issue. I mean, to the best of my ability to determine, I don't think it's that issue. But thanks. Yeah, 1957, Fonda, great movie. All right, let's do another story. Does Mr. Smith goes to Washington count as a lawyer movie? I don't think so. But it's a good movie. I do not like A Few Good Men. I am on record. I am on record as being antagonistic to A Few Good Men. I do not like A Few Good Men. I think it's a lousy lawyer movie. I do not like A Few Good Men at all. Demi Moore's character in particular pisses me off repeatedly. Now we're asking very personal questions, training. We're not going to discuss what medications or what I do or do not use in any detail. That's very impolite to ask. Is it because I can't? It's because I can't handle the truth? No, it's because it's bullshit. It's a bullshit movie. It's bullshit legal tactics. Demi Moore's character sucks. The whole movie doesn't make sense. I hate it. All right. Yeah, it sucks. It's a bad movie. Bringing hope to this lawyer's heart. The Supreme Court has granted review in a case that openly questions whether or not Chevron versus NRDC should remain good law. This excites me. This excites me on levels. Will all my Christmases come at once? I don't know. But there's hope. This case, Chevron versus NRDC, is one of those cases that drives me absolutely crazy. I hate it so much. It basically says in so many words that administrative agencies, federal administrative agencies, FTC, FCC, SEC, IRS, whatever, that they get control over their own interpretation of the law. So there's statutes that exist that give the agencies, the ATF, FBI, whatever, there are statutes that give all these wonderful agencies power and says what they can do and how they go about it. And Chevron versus NRDC says that the agencies themselves are the one that gets to interpret those statutes. So they get to figure out what their own power is. And the courts will just agree with them because they can't be wrong, basically. So it's basically the ultimate in self-dealing. Here is a document that says what you have the power to do. You have the power to interpret the document and figure out what power you have. Anyone see a problem with that? I sure do. So we're looking at this and maybe we'll be able to undo this. It'll be great. All right. So we've granted review in these cases which deals with the interests of retaliatory intent for whistleblower claims under Sarbanes-Oxley, which, that's interesting, I guess, too. How much intent do you have to have when it comes to punishing a whistleblower? So if a whistleblower blows the whistle against you and you harm them in some way, how much does your intent matter? Okay, that's kind of interesting. Not our discussion for today. More interesting is the second case, Looper Bright Enterprises versus Raimondo, which deals with this issue. The Supreme Court granted certiorari on question number 2 alone. And question number 2 is whether the court should overrule Chevron, or at least clarify that statutory silence concerning controversial powers expressly, but narrowly granted elsewhere in the statute, do not constitute ambiguity regarding deference. So yeah, we are doing this, and this is Paul Clement's case, because of course it is, because Paul Clement is an OG badass at the Supreme Court. So Paul Clement is going to be arguing that maybe we should overrule Chevron or at least clarify it. I'd be down for overruling Chevron. That would be fine. So should we do that? The perspective of overruling Chevron already has legal commentators in a tizzy. Yeah, I'm in a tizzy. I'm happy. I'm excited. I'm hopeful. But it's important, of course, to note the question is not limited to whether it should overturn Chevron. Yeah, well, I'll still stand on the hope. The question asks whether or not we can limit Chevron, confine Chevron to its proper domain. There's a proper domain for Chevron? I don't know, man. I don't think there really is a proper domain for the Chevron. Proper domain for Chevron would be a waste bin. But, okay. By making clear that statutory silence does not constitute ambiguity. How can silence be ambiguous, right? The statute doesn't say anything. So maybe what it was really trying to say is we have this power all along. By Congress not writing things, they meant that we had power. So here's 5 things that Congress said we could do. And they didn't say anything about number 6 at all. So it must mean that they wanted us to have that power. So we're just poofing power from nowhere. That's nice if you can get it, just create it yourself. It must be Congress didn't write it, so it must be they want us to have it. Okay. So maybe we could limit Chevron to the idea that Congress only delegates you authority that they actually delegate. Wow, what a restriction. So maybe that, or maybe just Chevron itself should die. I'm hoping for Chevron should die. That'd be great. The court's cert grant brings to mind the court's 2013 grant in a different case, City of Arlington versus FCC, in which the court limited granting the underlying Chevron question. In Arlington, the agency prevailed over a forceful dissent from Roberts that stressed the foundational principles. So this isn't the first time the Supreme Court has looked at the possibility of overruling Chevron. But of course, since 2013, the court's membership has changed. And maybe now we have enough votes to overrule this horrible, horrible law. This doesn't make any sense. Let's overrule Chevron. Chevron sucks. Let's get rid of it. The Chief Justice previously wrote, it's the job of the courts to determine what power an agency has. Wow. That would be great. Do that. Maybe the courts are the one that should interpret what laws are. Maybe that's what they should do because that's what courts do. Right? Executive branch executes, legislative branch writes laws. What does the judicial branch? They interpret the law. That's what they do. So here is a statute Congress wrote. Here's a statute Congress wrote. What does the statute mean? Who should we ask? Maybe we should ask the judicial branch. That sounds like a good idea. Instead of Chevron saying, hey, how about asking the executive branch what the statute means that they themselves are supposed to enforce? This is the statute that limits them, by the way. This is the statute that grants them power and also limits their power. Let's ask them in what ways it grants them power and limits power. That sounds like a great idea. Who came up with this nonsense? Lord. The Supreme Court in recent years has not cast doubt on Chevron as much as ignored it, which maybe is a sign that perhaps Chevron has come to an end. The court has not relied on Chevron since 2016. Not that that has prevented the courts of appeal and the federal district courts from applying Chevron everywhere. So the Supreme Court may not have applied Chevron in the last 7 years, but to some extent, it doesn't matter that the Supreme Court hasn't applied Chevron because the Supreme Court doesn't hear that many cases. All the real law is happening at the Court of Appeals level. It always does. And so if the Supreme Court just doesn't do anything, well, the courts of appeals just keep churning out law because they're just saying, oh, Chevron exists. Chevron exists. So the Supreme Court might have been like not relying on it, but it doesn't matter much because the courts of appeal have no choice but to continue applying it because for the moment it's good law. So the Supreme Court's silence, unfortunately, doesn't afford the courts below them the ability to just be like, oh, it must be its dead letter. And that's not how that works. The court, of course, has left in place Chevron for the lower courts, which use this doctrine all the time. And while making clear the court should defer less often, but not very clearly. So, yes, there has been some very mild, in my view, taming of Chevron, but I don't think that taming is even worth mentioning, to be honest. So Chevron is slightly weaker than it was in the past, but it's not worth talking about because it's still a massive, massive behemoth. While most calls for overturning Chevron come from the political right, it's worth remembering that Chevron was initially embraced by a Republican administration and conservative justice as a way to push against broad, purposeful interpretations of statutes that compelled agencies to regulate more aggressively. Yeah, that was a mistake. That was a mistake. The conservatives were mad that the courts were doing purposeful interpretation. And so they're like, oh, let's get around the courts by giving the administrative agencies more power. That'll be good. Yeah. So, well, that was a mistake, but that's okay. I'm willing to admit when we made a mistake. Telling courts to resolve all statutory ambiguities themselves is not a particularly effective way to constrain the administrative state, at least without greater guidance on how statutes should be interpreted. It's a fine way. It's a fine way. You know, undoing Chevron will not undo the world. Okay, it's a decision that will matter at the margins, but those margins are important and will prevent the worst abuses of agencies. So agencies are still going to have crazy amounts of power, even if we get rid of Chevron. Because if we get rid of Chevron, what we should do is properly interpret the statute and be like, what did Congress actually write? But what Congress actually wrote a lot of the time were massive grants of power. So will this completely destroy the administrative state? No, not really. They'll still be able to do at least 90% of the things they were doing before. But it will prevent them from doing the stupidest stuff and the stuff that goes well beyond the bounds of anything that statutes wrote. So, and also it will properly interpret and properly apply the law. So even if somehow every decision wound up exactly the same, it would still be fundamentally the right thing to do. Because the fundamental issue is who gets to decide, and the courts get to decide. If what the courts decide is that the agencies were really right all along, then, okay. But that's the way it's supposed to be. So I'm still thrilled, even though it will not mean the death of the administrative state. But, hey, one step at a time. I'll take what I can get. Thus, that brings us to the end of discussion about the Supreme Court potentially limiting or ending Chevron, which makes me very, very happy. Chevron versus NRDC is a stupid, stupid case. I don't think it makes any sense. When it comes to interpreting statutes, leave it to courts. And then, of course, Chevron wasn't the only case. Chevron was also followed by a case called Auer, and then also followed by a case called Brand X, which said that not only do the administrative agencies get the power to interpret their own statutes, they also get the power to interpret their own regulations, and they get the ability to change their mind. So even if they flip 180 degrees on the interpretation of a statute, they're still right. So the law means basically whatever they want to mean at whatever time, whatever's convenient, which doesn't make any sense. Congress wrote a law. It means something. It might mean a broad thing, but it means something, and we should let the courts decide this. And if they overrule Chevron, it may not mean the death of the administrative state, but I'll be a very, very happy uncivil law. And that, for the moment, brings us to this end of discussion of this story. All right. How are we doing in chat? Are we all having a great day in chat? Thank you for the 170 of you who are currently here. Love you all for being here. Thank you very much. You are the greatest, as always. We love you, chat. Which agency would Chevron have the largest impact on? I don't know. I really don't know. The EPA? EPA is a reasonable bet. Sandra Ramirez gets 5 memberships to the channel. Thank you very much, Sandra, for your donation. As always, it is severely appreciated. Thank you very much. All right, let's see. I got a whole bunch of depressing stories. Let's see. Should we do one of the depressing stories? Dude, this is pretty depressing. All right. All right, let's do this one. This is good. Brace yourselves. A brand new bride was killed by a drunk driver just moments after leaving her own wedding reception in a golf cart in South Carolina. The wedding had just happened, and this drunk driver killed this brand new bride. That sucks. Pictured on left here is the woman who is accused of the drunk driving. Pictured on here on the right is, well, the bride who is now dead. That sucks. That sucks hard. A bride was killed moments after her wedding reception when the golf cart that was carrying her and her husband away from the reception was struck by a drunk driver going more than twice the speed limit. Samantha Miller, 34, died after Jamie Lee Kormosky, 25, allegedly slammed her rental car into the back of the golf cart in Folly Beach, South Carolina, a place I know well, at around 10 p.m. Miller's new husband, reportedly suffered brain injury and is critical condition. So, unclear whether he's even aware of what happened at this point, to be honest. 2 other people in the golf cart were also hurt. The golf cart was reportedly thrown 100 yards and rolled over several times as a result of the impact. That would be pretty severe. All occupants of the golf cart were injured, including the 1 fatality. 3 other people were injured, with 2 in very serious condition and 1 with minor injuries. The person killed in the crash was Samantha Miller, who just earlier that evening celebrated her own wedding. The occupants were being transported back to the rental house where they were staying when they were struck. The woman who hit them is not injured in the crash because she's in a car and they're in a golf cart. Reports say that the woman was going 65 miles an hour at the time of the incident. The speed limit was 25. So, yeah, she's being charged with 3 counts of DUI and 1 count of reckless homicide. First responders say they smelled alcohol, which, as I made contact with the woman, I smelled odor of alcohol coming from her breath. The sergeant asked her if she had anything to drink, and she replied she had 1 beer and a drink with tequila about an hour ago. Yeah, that's a lie. That's a lie. She had a little bit more than that. When asked to rank herself on a scale of 1 to 10 on how drunk she was, with 10 being the most impaired, she said she was an 8. She strongly refused to submit to sobriety test and became uncooperative, unsurprisingly. When she tried to stand, she was unsteady on her feet and almost fell down. Police then obtained a blood sample, which was sent to SLED, which hopefully will not screw this up. Please do not screw this up, SLED. The Associated Press reported that the golf cart did have lights, and it was legal to drive at night, so that's not the problem. The mother has launched a GoFundMe for the injuries. I was handed wedding ring in a plastic bag at the hospital 5 hours after he placed it on his finger, and they read each other's vows. Wow. That sucks hard. She says her son is in critical condition and has 2 reconstructive surgeries, numerous broken bones, and a brain injury. I don't even know how you come back from this. I don't know how you come back from this. This would be, I can't, if this happened to me, I would not be long for this world, guys. I am not strong enough to deal with this. This is too much. As of Tuesday, the GoFundMe has raised $400,000 apparently to help fund various costs. Not that the money can fix this. This woman going to jail forever would help a lot. Maybe if she suffers enough, I'll feel better. Yeah, so we have a probable cause affidavit, but we don't need to read that. I hate this. How do you come back 1 second at a time? I don't think I could come back from this, man. I don't think I could come back from this. Thus, we reach the end of the story where the woman on the left was drunk driving in her car at 65 miles an hour in a 25 mile an hour zone and hit the woman on the right who was in the golf cart, and now she's dead. Just as they were literally leaving the wedding, they were leaving the reception in the golf cart, this woman hit her, and now she's dead. And if there's any justice in this world, this woman will go to jail forever and suffer a horrible, horrible life because she's inflicted so much pain. And I can't even begin to fathom how the groom will deal with this, because I don't know that I could deal with this. And this is a lot. This is a lot for anybody. And that will bring us to the end of discussion of this tale. Sue her to oblivion while we're at it, too. Take every dime she ever had and every dime she ever will have. Strip her of every possession she's ever had in her life. Make her live homeless in the streets or something, I don't know. I know life for DUI isn't common. I'm well aware. Man can hope. Well, it's felony homicide. It's not just any DUI, but still. Let's see, what else do I want to cover today? There's just, I've got lots of depressing stories. All right, I guess I'll cover this lawsuit, and then I'll cover maybe a more depressing story, and then we'll try to end with Florida person. Cheer it up, Kurt. Yeah, well, some days the legal news doesn't really allow for that, but I'll do what I can. Founders Brewery is facing a racial discrimination lawsuit in hours after it closes its Detroit tap room. So things are not going well for many businesses, including particularly perhaps Detroit, which has suffered economically for years, even decades at this point. And Founders Brewery has closed one of its tap rooms, bringing some sort of closure to another area of Detroit, and is now being faced with a racial discrimination lawsuit relating to some of its activities. So Founders announced its closure of its tap room and then got sued by a black employee who said that she was employed or promoted for purely optic reasons and subject to egregious harassment. So that's interesting. Racial discrimination through promotion. That's an interesting angle on things. So I was discriminated against by being promoted. Okay. In the lawsuit, the woman claims that after nearly 2 years of working for the brewery, the work environment became so racially hostile she had no choice to resign. She alleged harassment included coworkers intentionally mispronouncing her name, warning her to be careful a child does not steal any money from the brewery, and telling her she's not struggled enough to be black. I wonder what the race of some of those people saying some of those things were, incidentally. But okay. Her lawsuit was announced in district court about 2.5 hours later. Founders announced it was closing its Detroit tap room because of struggles to regain foot traffic after COVID-19. Dillard's lawyer, who in 2019 settled another racial discrimination lawsuit with the same brewing company, questioned the timing of the announcement. I don't think they closed the entire tap room because of your lawsuit. That seems odd. Miss Dillard spoke openly about racial hostile treatment to founders during her exit interview. It's difficult for me to objectively accept the abrupt announcement to permanently close mere hours after the complaint. I mean, I'm not sure how those two things would matter. If she's discriminated against, I don't. It doesn't matter that they're closing the tap room. So I don't know why you think they'd be doing it. What the benefit would be. The tap room had 38 employees among 400 workers, so they lost about 10% of their workforce as a result of this. In announcing the closure, they said the decision involved a lot of careful consideration. I would think. We've explored every possible avenue to correct business and gave as much time as we could. We're working to find new positions with employees. This is the second lawsuit to hit the brewery in 5 years. The last plaintiff was Detroit Taproom Events and Promotions Manager, who alleged that founders tolerated a racist internal corporate culture and founders fired him in retaliation, which that was settled because sometimes settlement is cheaper and faster. All right. I think I'm done with the story. Thus, that brings us to the end of the discussion of Founders Brewery, who is being sued for racial discrimination by a woman who alleges that she was promoted as a result of racial discrimination and also was engaged in a racially discriminatory, racially hostile environment. So, as Founders announces the closure of its facilities in Detroit that are pictured here. So, all that will have to be resolved, of course, in the court system. So we'll see how all that is going. And that, for the moment, brings us end to discussion of this story. What was her name? Her name was Na Na Nama Nima Naima Dillard. I'm gonna say Naima Dillard. Why did I randomly stop halfway? Because I was done with the story, Simon. I don't want to talk about it anymore. My channel. That's why. All right. Let's see. All right. Let's see. Alan Parker gives another 20 memberships. That's very, very kind, Alan Parker. Thank you very, very much for your continuing support of the channel. All right, let's discuss two stories of women abandoning their brand new children to die. That's uplifting. Let's discuss two stories of women who both abandon their brand new children to die. That's exciting. Let's do that. Okay. A woman has been sentenced to 27 years in prison for abandoning her newborn son to die on a freezing bench, just leaving the child exposed to the elements and freezing cold. Just brand new born child, just dispose of it like trash or something. And the woman has been sentenced to 27 years. Let's learn more about this horror show. Here is a picture of a woman who left her newborn son to die on a freezing bench. Exciting. The judge sentenced the woman who is 51 for abandoning her newborn son. So apparently she's having children at 51, which, wow. As previously reported, authorities say she also discarded a baby girl who was found wrapped in a towel and floating in the water, but they haven't charged her with that. Oh, okay. So maybe she's a serial child abandoner. So she left a child, a son, to die on a freezing bench, and apparently also discarded a baby girl found wrapped in a towel and floating in the water. Exciting. She's been sentenced to 27 years and 2 months. She admitted going to Methodist Beach in Florence Township, Minnesota in 2003, according to plea documents. The beach was isolated, thus deserted and dark. While at Methodist Beach, I gave birth to an infant male who was born alive. Oh, so she wasn't 50. She wasn't 51 at the time. Okay, that makes more sense. So this happened in 2003. So this was 20 years ago. So she was 33. Okay, that makes a lot more logical sense. All right. So she's a 33-year-old woman who abandoned her brand new son to die. Or no, apologize. She'd be 31. She's a 31-year-old woman who abandons her newborn child to die. Oh, okay, that makes more sense. So she's 31, gives birth to a brand new boy, and lets him die on a park bench. Okay. She said she had hidden her pregnancy from others. She said she put the baby on the sand near the water's edge without clothes or a blanket. Temperatures at that time of year would usually be around freezing. After giving birth, she told no one about leaving him on the freezing bench. I left the infant male on the beach, walked away, got in my car, and drove away with no intention of ever returning. She, of course, admitted that she knew that he'd die of exposure. The boy was found dead in 2003. Autopsy determined the infant was a full-term newborn male infant who was probably born alive. Initial findings note blunt force head trauma, including multiple small areas of hemorrhages, subdural hemorrhages, and cerebral hemorrhages. There were no congenital abnormalities noted. The coroner determined manner of death was homicide. She was sentenced for second-degree murder with intent in exchange for her plea deal. According to documents, she had 2 other children at the time of the incident who were 6 and 9. Investigators say she also abandoned a newborn daughter in 1999. So apparently this is part of a streak. So that'd be 4 years earlier when she would be what, 27? So when she's 27, she apparently abandons a newborn daughter. In 2003, she abandons a newborn son to the elements. Exciting and interesting. According to the complaint, she said their pregnancy caught her by surprise. She gave birth in a bathroom. She claimed the baby was born blue, not breathing, and was not crying. Freaked out, she placed the baby in a towel. She estimated a day passed, but wasn't sure because she had been drinking heavily. She never told anyone what happened. She drove to Bay Point Park in the middle of the night, put the baby in the water near the boathouse, and walked off. So her newborn daughter, yeah, that's apparently what happened. And she's not sure about how much time passed between the birth and the abandonment because she'd been drinking really, really heavily. All right. Thus, that brings us to the end of this story about this woman, now age 51, who's going to prison for at least 23 years. And if justice is kind, will be charged in the death of her other daughter. Or if justice is kind, she'll die in prison because she's 51 and maybe she'll die in prison from natural causes. So, yeah. So, this woman, when she was 27, apparently abandoned a child by putting it into a river. And then when she was 31, abandoned another child by leaving it on a freezing bench to die from the elements. So this is apparently how this woman deals with problems. So she has been convicted and sentenced to prison, bringing some justice to this story. And that, for the moment, brings us to the end of discussion of this story. Ugh. All right, let's discuss woman number 2. Okay, New Mexico is what I thought. What legal merit is in there in just reading horrible things that just happened? Well, this channel, at least the streams in the morning, aim to bring you legal news so that you can be more legally informed. So this is legally related news. That's the merit of it. The merit of it is to show you legally related news. Also to show you that, people are getting convicted for, that justice is happening. A woman going to jail for 20 years for murder is legally related. It's legal news so that you can understand better what's happening legally. So, I mean, that's, seems self-evident to me. We cover all kinds of legal news. Sometimes it's where the law is developing. We cover a lot of appellate cases where the law is developing and the law is moving. So we cover a lot of cases where the law is moving. In this situation, the law is not moving. The law of murder has been established for a while, but it's like, here's some legal news that happened like recently. Seems good. I don't know. What legal issue was interesting in that? Okay, well, maybe you didn't find it interesting then. Can't please everybody. Moving on. A New Mexico woman has been caught on tape tossing her baby into a dumpster and has learned her fate. So another woman charged and convicted with just literally throwing her child away in the trash, because apparently that's a thing that sometimes women do. That sucks. The 19-year-old mother in New Mexico has been sentenced to 18 years behind bars for stuffing her newborn baby in a plastic bag, filling it with trash, and tossing it into a commercial dumpster behind a shopping mall. So, yeah, the judge ordered 18 years in prison, finding her guilty on one count of attempted first-degree murder and one count of intentional child abuse relating in bodily harm. The judge, for some reason, agreed to suspend 2 years of the sentence because they think that mental health is somewhat a factor, and age also is a reason for leeway. So she'll serve basically 15 years and be released when she is 34. So Not sure about all that, but okay. This was a heinous crime. To toss one's child into a dumpster like trash is something that's unforgivable. Yeah, a little bit. But apparently we're going to forgive 2 years of the sentence for some reason. Your child was very vulnerable. But for the grace of God and happenstance of 3 dumpster drivers, we'd be here on a murder case. So fortunately, the child survived. Even though they were wrapped in a plastic bag with trash and thrown in a dumpster. Somehow, the child survived because some dumpster divers happened to come along and find this child while still alive. So there is some grace in this world. The prosecutors had sought a harsher sentence, emphasizing lack of remorse. Yeah, I mean, this seems like something that would counsel for a pretty stiff sentence. Your Honor, what we see here is a pattern of someone not only showing lack of remorse. Let me try that sentence again. Your Honor, what we see here is a pattern of someone who not only didn't show remorse, but someone, in fact, who took deliberate steps in her own recollection of the event to minimize her role. It's something we see manifest and clear on the video, that she was attempting to kill her own child. Yeah. The woman apparently addressed the court saying she did regret her actions, saying, I regret I deprived him of having a loving and caring family. Yes, he has a dad and his dad's family, but when my family and I love, we love hard and we love with everything I can, which by implication means that she had no love for her child. I mean, if it's true that when she loves, they love with everything that she has, the logical conclusion would be that she had no love for her own child. So, yeah, to my family, everything is to us. My nephews and nieces are everything. Uh-huh. Well, your nephews and nieces are everything, apparently, but apparently not your own brand newborn child. Way to go. The prosecutor, for their part, said, we're thankful the court found this especially heinous crime was serious, violent offense, and defendant will receive a just punishment. It's the bare minimum, in my view. The bare minimum. 15 years for the attempted murder. This sentence is warning to all who try to kill innocent children. You'll be held accountable. Not accountable enough, ma'am. Not accountable enough. Officers had responded to the scene in January of 2022 in response to a 911 call about a baby being found in a dumpster. Upon arriving at the scene, the first responders found 2 males standing near a dumpster and a female sitting inside a vehicle holding the baby. So this trio came along and found the baby and called 911. Good for them. Authorities say the baby was wrapped in a bath towel that was dirty and wet, and had dried blood, and the umbilical cord was still attached. EMS rendered aid before rushing the child to a hospital. Shortly thereafter, the newborn was flown to Lubbock Hospital for more specialized pediatric treatment, because I would think the child might need some more advanced treatment. Yeah, that's pretty logical. Yes, I am on Rumble. By the way, all this content is mirrored on Rumble. So for those of you who want to, follow this on Rumble as well, that is also an option. All this content is automatically mirrored on Rumble. So yeah. Thank you for asking. The 3 people who found the baby told investigators they were looking for anything of value that might have been thrown away when they heard crying. Thinking it was a dog or a cat, they removed the bag only to find a newborn. The female then took the baby into the car and helped keep him warm while one of the men called for help. That's nice. I'm glad that we were able to do that. Investigators then obtained surveillance footage from cameras nearby, which showed a white four-door Volkswagen Jetta pulling into a nearly empty parking lot and stopping in front of the line of three large dumpsters at 2 p.m. A woman exits the side door and opens the back passenger door. She grabs a black bag from the back seat and throws it into an open dumpster farthest to the right before getting into the vehicle and driving off. The incident took 30 seconds. Based on footage, they said the baby was in the dumpster for 6 hours. Wow. 6 hours abandoned in a dumpster and managed to survive. Man, jeez. Lord. The video says it all. It clearly called her actions, expressions still difficult for people to watch the video. Yeah, I would think so. Thus, that brings us to the end of the story about Alexis Avila over here, 21, who apparently, I apologize, she's not 21, she's 18. Let me redo the line. I gave her more years than she deserves. That's my bad. Thus, that brings us to the end of the story about Alexis Avila over here, 18, who apparently decided to abandon her brand new child into a dumpster. You know, not for nothing, but every single state has safe surrender laws. Every single one. So she could have taken the child to a hospital and left it at the hospital, and that would have been legal if she wanted to go that way. Or a fire station or something like that. Depends on the state law where specifically, but fire stations and hospitals tend to be places where you can do this. So she had options to give her child away in a way that would have ensured her child's safety, and instead decided to throw it away in a dumpster. So, yeah. So I'm not sure what that's all about, but that's what happened. And that, for the moment, brings us into discussion of this story. Not the Craigslist free section. No. Not the Craigslist free section. No. No. I don't think that's one of the options. Someone said they sent me a story on Twitter or something for a cheer up. Let's take a look and see what we got. Let's take a look. Need your wrench? That's true. Let me do it now. Yeah, dark humor, definitely dark humor. We definitely do the dark humor because we need dark humor in our lives. All right, Rose, you're now a moderator. Moderate for great justice. All right, let's see. Where were we? Oh, yes, I was going to Twitter when I got distracted. I didn't get a notification. Did you send it to me on Discord? No. You said you sent me something. I didn't get something. I'm confused. Oh, here it is. Is it illegal to garden in the nude in Illinois? Take a look. Apparently, people garden in the nude sometime. I don't know why you would do such a thing, but apparently some people do that. Hey, you're fine, Rose. You're fine. I wouldn't have remembered otherwise. I totally would have forgotten to do it forever. So you're good. Always looking for a good moderator. Help keep the help keep the chat in line. Keep it a friendly place where we try to build each other up rather than tear each other down. And I need sunscreen. Yeah, I put on sunscreen when I was out and about, and I still got a little bit of sun. Maybe I didn't put on enough sunscreen, but you know, we're fine. All right. Dun, 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 dun. Well, we could do the story about the 76-year-old gynecologist who's being sued by for medical malpractice by 83 female patients for sexual assault. Uh, the patients range in age from 15 to 73. So apparently he accepts all people. Apparently, this is I don't even okay. Apparently, the individual was known to have erections while women were giving birth. So he'd be in the hospital room, apparently, as an OBGYN, as one does, and the woman would be giving birth, and apparently he'd get an erection from it. And to the point his own staff had to apparently cover his lap to hide it. That's a lot. That's a lot. All right, let's do this story. This is a lot. I okay, let's do this story. This is a lot. Yeah, this is a lot. Yeah, you can't sometimes you can't help but laugh at the absurdity of it. You know, it's like, because it's just absurd. It's so much, right? It's so over the top. As like, so it provokes laughter from me because it's like, you can't believe it's true. It's just so much. And I'm like, wow, this is just it's like, yeah. So sometimes I laugh. That's one of my reactions to it. As I don't know that that's that uncommon a reaction. A lot of people deal with situations a lot of different ways, and so one of the ways I try to deal with it is by laughing because it's like if you don't laugh, you cry or something. And so yeah, it's like this is just so absurd. It's like wow, it's like you just like how is this a thing, man? Damn. Yeah, same with like cops and like, yeah. So it's like, yeah, there's a lot, or medical staff, right? They laugh the horror. It's like, cause it's just like, wow, this is so over the top. You can't help but laugh a little bit sometimes. So I'm not sure exactly what version of funny that is. I mean, it's not ironic. Is it juxtapositional? Is it? I guess it's the defiance of expectation is what makes it funny. Because one of the things that makes a punchline in comedy, like on a technical level, one of the things that makes a punchline on a technical level is, and this isn't the only thing that makes a punchline, but it's one of the ways to have a punchline is for it to subvert expectations. Right? You set up the joke, and the punchline subverts the expectation. And that the funny is in the subversion. So, like, the fact that this is such a subversion of what you expect, because of course you expect a medical professional to be a medical professional, and he's very distinctly not, in a very egregious way. So the subversion is funny. I think maybe that's it. Okay. Anyways. All right. A renowned and prolific gynecologist has been accused of sexual harassment and sexual violations and all kinds of misdeeds, among other things, during deliveries of children. As women were giving birth, he would apparently get aroused. That's a lot. He is now facing a lawsuit from lots of women in relation to his medical malpractice. Here is a picture of William Moore as he is in this photo appearing at a hearing regarding the potential suspension of his medical license, because maybe we should suspend his medical license. I don't know. Just a thought. William Moore, who is 76, is an OBGYN who has practiced in Indiana since 1994. So he's been in practice for 30 years. He is now being sued by 83 women. 83 women for medical malpractice who age in range from 15 to 73. So apparently he accepts all women for his abuse. The lawsuit alleges, among other things, that among the 83 women, some of the things that he would do would include sexual assault during what should be a routine exam, photographs of their private parts without consent and for without medical reason, and making inappropriate sexual comments. The lawsuit names Moore, his practice, and the hospital's defendants. Moore, for his part, retired abruptly in 2022, shortly after the accusations began to surface, when a former patient's Facebook post about his misconduct went viral. So, as often happens in these kinds of situations, one woman came forward, and then other women came forward. And now 83 women have come forward. That is a lot of women, right? That is a lot of women, right? We're not just talking about like 2 or 3 or 4 and be like, oh, okay, maybe things aren't where they appear. 83? That's a lot of women. It's like there's probably something here that's worthy of investigation. Might want to look into it a little bit more. So in January, the Office of the Indiana Attorney General filed for a suspension of his license, which, is just the start, I'm sure. Apparently, among other things, he's also accused of assaulting patients during pelvic exams, not wearing gloves during pelvic exams. That seems problematic. And ordering unnecessary tests. And apparently was also known to get physical erections when women were giving vaginal delivery of children, to the point his own staff had to cover up his laugh. So apparently he's so turned on by it, the act of giving birth, that he'd get physically aroused during the birthing process. Wow. The allegations raised by the Jane Doe plaintiffs in the Attorney General's petition were pretty graphic. One person listed as patient A said that during 2021 exam, Moore inserted speculum into her vagina, took photos with an iPhone, which I'm not sure that's necessarily the proper medical procedure, then inserted his fingers and rubbed her clitoris in a sexual manner while asking that she do Kegel exercises. Apparently also had a medical assistant come in the room and take another photograph while he opened her labia. Wow. Wow. That's a lot. Patient B said during a detailed medical appointment, during which the person allegedly asked her if he had a boyfriend, perform oral sex. Then saying, "Oh, you're so pure. If you aren't sexually active within the next year, I'll have to manually break your hymen because it's hard for me to see." Where do you even start? Where do you even start with that? Wow. One hospital nurse, identified as AM, was told by fellow nurses that Moore would often have to cover up his lap during vaginal deliveries to hide erections. The same nurse also said that a person who worked at a cellular store told her that after she gained access to photographs on the cell phone. She found photographs of women's sexual anatomy. The nurse said she reported these things to the hospital, but was told the hospital could not take action, as she would not be privy to any further investigations. So apparently, the nurse might have alerted the hospital, and the hospital might have not done something about it, which might be why the hospital is getting sued. If the hospital was aware and didn't do anything, well, that's a problem. In March of 2023, his medical license was suspended. So I guess he won't be doing more of those exams, at least officially. He's denied allegations, said he's prohibited from patient confidentiality laws from discussing specific care of a patient. Sure, that's the problem. Apparently, the same individual also became the Grant County Public Health Officer in 2019. So he became a public official on top of everything else. A role in which he oversaw healthcare. That's interesting. Lawyers for the 83 plaintiffs said that more victims were expected to sign on, I would think. Under Medical Malpractice Act, a doctor is liable for not more than $250,000 for any one case. So, yeah. So there's a limit of how much they can get, but but of course each act would be distinct. So the lawsuit also has to deal with the 2-year statute of limitations. So many of these lawsuits might get thrown out because of the statute of limitations for such lawsuits. So that's going to be an issue, arguing that it's unconstitutional, which it's not, and arguing the women could not have been expected to recognize the scale of their actions, which I don't know. It seems, they have statute of limitation problems out the ass for at least some of this stuff, for sure. Of course, they're also facing criminal investigation, which you would expect, and the parties have not responded. 2-year statute of limitations is pretty typical. Statute of limitations for civil cases typically is about 1 to 3 years, depending on the cause of action, depending on the state. So 2 years is a pretty typical statute of limitations number. But yeah. Thus, that brings us to the end of discussion the story about David Moore, who apparently assaulted at least 83 women. More to follow. Unclear how many of these women will ever see justice because the statute of limitations on it has passed for many of the women. But at least some of the women might be able to recover for some of this. And also criminal investigations are underway, which I think would yield some criminal charges in the near future for some of this stuff. Also, the hospital, of course, for its part, may suffer as well. So we'll see how that all develops. At least for a moment, that brings us end of discussion of this story. Over 65 for elder abuse. Yeah, good call. Good call. All right. Let's end. I will just give you a couple other stories that we didn't cover today, just so you can know. But there was a Texas manhunt that ended after the suspect was caught hiding in a laundry pile. The person had been on the run after killing 5 people in the city of Cleveland, Texas, was found Tuesday hiding in laundry in a closet. Francisco Osperera, 38, in the city of Cut and Shoot, Texas. There's a city called Cut and Shoot. Yes, there is. Okay. The city of Cut and Shoot is 40 miles north of Houston. Population 1,087. Okay. There's a city called Cut and Shoot in Texas. All right. He was arrested in Cut and Shoot, Texas. He's accused of killing 5 people, including a 9-year-old boy, in the city of Cleveland, Texas, and was arrested in the city of Cut and Shoot, Texas. Okay, so that's something that's happening apparently in Texas. Now I want to move to the city of Cut and Shoot, Texas. I wonder if it's a nice place to live. Oh, dude. Dude, how can you not love that? Oh man. I want to live there. I want to live in Cut and Shoot, Texas. I can run for Cut and Shoot City Council, and I can have my meetings at the Cut and Shoot City Hall. Fantastic, man. Fantastic. I'm feeling it. I'm feeling it. This is good shit. Yeah. Yeah. Okay. Yep. That's okay. Great. Looks like a restaurant. Does look a little bit like a restaurant. Yes, I tend to agree. Cut and Shoot is within the Conroe Independent School District and the Lone Star College System. Schools serving Cut and Shoot include Austin Elementary School, Grangerland Intermediate School, Moorhead Junior High School, and Caney Creek High School. Deborah Maffett, who was Miss America 1983, grew up in Cut and Shoot, Texas. So, okay. I have the hat. I know. I know. I do have the hat. I got it down. Yeah. I got everything I need. Isn't it a huge story? I mean, it's a significant story, yeah. It's definitely a significant story for sure. Yeah. All right, let's end the stream with Florida Man. For today's Florida Man story, we bring your attention to Florida woman arrested after her dogs attacked and killed a man, ripping off his ears and nose. So, Florida woman is the proud owner of some dogs. The dogs killed a man in Florida man style, and now the woman has been arrested. Let's learn a little bit more about Florida woman. Pictured here is Kathleen Ann Taylor, a Florida woman named for sure, who has been arrested in response to this incident. The 35-year-old Florida woman has been arrested after 3 dogs she owned viciously attacked a 63-year-old man who was walking in the area. Kathleen Ann Taylor was taken into custody and charged with 1 count of homicide, negligent manslaughter, a second-degree felony. So, unsurprisingly, you are responsible for your dogs. And when the dogs kill somebody, which is a horrific way to die for sure, you're going to be held to account for that. According to the sheriff's office, deputies responded to a call about the unresponsive adult male at around 10 p.m. on February the 24th of 2023. The 63-year-old male was found with injuries to his head and torso and pronounced dead due to the injuries. The man lived in a trailer on the property, and it appears the 3 dogs attacked him and ultimately took his life. The owner of the property and dogs is Kathleen Taylor. So he lived there, and then the dogs attacked him and killed him. She is charged with failure to properly secure her home or kennel, or have enclosures designed to keep her dogs from roaming free. There's also been a notation of a history of problems with animal control agents and being fined several times for allowing her animals to roam free. So this is not a one-off issue. This is an issue that has occurred many times with her dogs roaming free and animal control getting involved. And still the woman didn't take action, which goes a long way to proving a reckless murder, right? Because now you have knowing disregard if you didn't have it before, right? So if you weren't aware before, you are now, having been warned several times about it. And so that goes a long way to a reckless murder charge. Yeah, you were knowingly creating unsafe conditions in which someone dies. So, yeah. Regarding the 3 dogs, authorities say multiple people in the neighborhood had filed complaints the dog had chased them. So, again, something that the city had dealt with. We had a lot of roaming calls. We had nuisance calls where the animals may have been chasing people. She obviously doesn't have the proper housing to take care of them. The animals, of course, also had recently bitten somebody. So again, showing knowing disregard. According to the probable cause affidavit, when deputies arrived at the scene, they found the victim lying on the ground with ears detached along with nose and left eye detached. What a horrific way to die. There were bites on each arm that were bleeding. That sucks. The witness told investigators that Taylor's at the scene and screamed that our dogs do not belong to her, but for getting in the car. The dogs do belong to you. The bottom line is if you have a pet, you have responsibility. If you have any reason to think your dogs are dangerous, you have even stronger responsibility. She chose to have a pet, she chose to have that responsibility, and now a man is dead. Yeah, she's going to prison, as she should. If convicted of the current negligent manslaughter charge she's facing, she would have up to 15 years in prison. Although I wouldn't be 100% surprised if they escalate those charges to a higher degree, because we can go to recklessness, knowingly creating reckless conditions. So currently being charged with negligent manslaughter, but would not be surprised if the prosecutor chooses to escalate those charges given the particular history this woman has. She had so many warnings and so many specific things that I think that they can make the higher charge stick. So we'll see how that develops. Thus, that brings us to the end of Florida woman Kathleen Ann Taylor, who apparently had dogs that were a known nuisance and would get out and about and chase people around and even previously bit people. Animal control had previously been involved, getting her dogs back under control, and she allowed her animals to go free. And now a 63-year-old man is dead. She is currently facing negligent manslaughter charges, but I think will probably face higher charges. Anyway, she's going to jail for a long period of time. And that brings us to the end of discussion of this story and the end of our stream. So other than the stories being a little bit downer today, I think today was a successful stream. So I appreciate those of you who are with me and spending time with me as we learn some of the legal stories going on in our world. It was a downer day because there was a lot of downer stories today, but you know, not all the legal news is always great. But I think, yeah, success. Yes, success, as we would say in improv. Yes, I think today was successful. I felt optimistic about it. I felt good about it. You know, it was fun. The chat was good. Lots of good chat participation. Oh, I should acknowledge super chats. See if there were any super chats that came in. I acknowledged hopefully all the people that did gift memberships, and a point of noting those. But let's see if there were any super chats that came in today as well. Because I think there was. Hold on. Let's see. Today is May the 3rd. There was one super chat. Yeah, from Elizabeth. Have you covered Ed Sheridan versus Marvin Gaye? Yes, I did cover Ed Sheridan versus Marvin Gaye, and I released an edited video about it yesterday. So, yeah. Awesome. Yeah, we'll definitely cut up some Chevron probably too. We need a complete reversal of Wickard. Yeah, reversing Wickard also wouldn't like be a massive deal because Wickard sets an outer boundary. And so overruling Wickard would overrule the outer boundary, and we have to find a new outer boundary. But I don't think it's quite the. There will be people who tell you that overruling Wickard would be like this huge deal because so many cases depend on it. But we just have to find a new boundary. So I don't think it's quite as huge a deal as some people make it out to be. Also, like overruling Chevron, I don't think it's quite a huge deal as people make it out to be. It's more of a legal purism thing, right? Because it's just like the boundary's in the wrong place. Wickard, the boundary's in the wrong place. And it needs to be moved. So the line is drawn in the wrong place. We need to move the line. But saying the line is in the wrong place, you know, the line might be drawn not much further from where it is, but it'd still be in the right place if that's where the right place is. It's just in the wrong place now. Same problem with Chevron, right? It's in the wrong place. So redraw the boundary line. But it wouldn't like massively overruling Wickard and overruling Chevron would not lead to like the immediate collapse of the entire administrative or executive state. It would just make them actually have to justify their rationales for once. which they'd be able to do a lot of the time. Because a lot of the time, they would be within the bounds of the law. So it would affect marginal cases, but so it might only make a 10% difference. But it's a 10% difference worth making, at least to me. You give me some Torches taco money? Oh, that sounds exciting. I'm looking forward to that. At least my allergy attack in my eye decided to come at the end of my stream today. So I got that going for me. Yeah. At least the allergy attack came at the end of the stream today. So I got that going for me. As my eye gets wielded shut for a little minute as my eye has an allergy attack. Congress bypassing the 27th Amendment? I'll look into it. Take the allergies to court? Yeah. Need to replace my air filter in my house is what I need to do. All right, I'm going to sign off for now. Then I'm going to cut this up and I'll post some stories today. That'll be fun. It's Wednesday today. Let's see. Am I going to do? I think I might do a stream tonight. I'm not sure what I'll do on. Maybe I'll do it. Maybe I'll do a Supreme Court reacts tonight. Do an oral argument on maybe the housing case or recent oral argument that looked fun. Maybe I'll do a stream tonight. I think that might be fun. Anyways, until later, my friend. I hope all is well. Cheers, my friends, and goodbye.